Hello, and welcome to this installment of the Pro Bono Partnership of Atlanta's webcast series. I'm Surisha Ganta, Education Director with PBPA, and today we'll be talking about recent updates in employment law. If we could move forward, thank you. We're going to be covering a lot of practical considerations for nonprofit employers today. There's been a lot happening in this space recently, and I'm excited to have with us today to walk us through this, Alex Milios and Lori Shapiro. Alex is an associate with Ogletree Deacons, where she advises clients on labor and employment matters. And she has experience litigating a diverse range of matters in both state and federal courts. And Lori is PBPA's own senior employment counsel, where she advises nonprofits on all sorts of employment queries. She recently celebrated her 10-year anniversary with PBPA, and I'm so excited to hear what Alex and Lori will say today, because they'll have a lot of great insight to share with us. Before Alex and Lori get into the substance of today's presentation, though, I'd like to take a couple of minutes just to share briefly a little bit about PBPA and our mission. PBPA provides free business legal services to Atlanta area nonprofits. And we do this by connecting small community-based nonprofits with volunteer attorneys, such as Alex, who work with law firms and corporations throughout the Atlanta metro area. PBPA provides free legal insight to small Georgia nonprofits, and we strive to meet nonprofits wherever they are in their journey and capacity. For example, we provide services to startups through our nonprofit boot camp, one-time engagements like our Vital Signs Forms Clinic, or we also provide ongoing one-on-one legal counsel to nonprofits that qualify as clients. In fact, we are currently accepting applications for our next round of bootcamp for diverse leaders. And I'm going to share a link to that for anyone that's interested in the chat in just a few minutes. And I'd also like to mention our Learning Center. Our Learning Center is full of podcasts, webcasts like this one today, and articles. And these resources are available to anyone for free and are tailored specifically to small Georgia nonprofits. If you have a legal question, you can probably find the answer there. And we also provide services to clients who meet these eligibility requirements. So if you're not currently a client and you're interested in applying, please go to our website and you can find the application there. And now a little bit of housekeeping. This webcast is copyrighted, and we welcome your general questions during this presentation, but please keep in mind that this is just general information. This is not legal advice. Please reach out directly to an attorney if you need to discuss specific concerns. For general questions on today's topic, you can use the Q&A to pose your questions for Alex and Lori. We have a lot to cover today, but we will strive to answer all your questions by the end of the program. And yes, I will be sharing slides in the chat momentarily, and this is being recorded. So both the slides and the video recording will be available on our website, probably in the next week or so. And with that, I will hand the mic over to Lori and Alex.
Great. Thank you so much, Surisha. And Alex, thank you very much for joining me for this webcast today. I really appreciate it and appreciate all the time and effort that you put in to help us get ready. And look forward to speaking with you in just a few minutes. But Alex and I are going to sort of build our discussion around a hypothetical situation involving a nonprofit called Happy Care Builders. And so I want to share some information with everyone about Happy Care Builders, and then we will discuss it as we go from topic to topic. So Happy Care Builders is a nonprofit that builds and operates childcare centers for homeless families. Lisa is the executive director of Happy Care, And Happy Care employs 25 people and has 3 childcare centers, all in Georgia. So we're going to start by telling you a little bit about some of the employees for Happy Care Builders. The first employee we're going to talk about is Mark. Mark is a Happy Care employee who was working as their program coordinator, and he was doing a great job. And so Lisa, the executive director, decided to move him into a management role. And in May of 2024, not too long ago, he was promoted to program director and given an increase in salary to $40,000 per year. Mark supervises the work of 2 part-time teachers who also help develop programming, and he oversees all of the programming for the child care centers. He's responsible for identifying, designing, and rolling out all of the new programming for the organization. He normally works a 40-hour week, and he's done so since the change in his position. Last week, there was a major initiative to implement a new program and to communicate about this new program to teachers and to parents. In addition to his normal 40-hour work week, Mark worked 3 extra hours in the evening to help coordinate with teachers and meet with parents. But Happy Care did not pay him overtime for those extra 3 hours that he worked last week. So let me start by asking all of you a question. And Randy, if you would please issue the first poll. Do you think that Happy Care owes Mark overtime pay for the 3 hours extra that he worked? Please indicate your choice on the poll, and then we'll discuss it. So it looks like about half of you think that Happy Care does owe Mark overtime, and 25% of you indicated that Happy Care does not owe Mark overtime, and the rest of you are not sure whether Happy Care owes Mark overtime or not. Oh, there we go. So let's discuss the overtime issues that arise here. Alex, what are your thoughts?
Yes, well, it's understandable that people might not be entirely sure right off the bat what the issues are, because this is actually a more complicated analysis than you might think. So it's okay that, we might not be sure right off the bat, because there's a lot of factors that actually go into this. Seems like a pretty standard and simple situation and a simple question, but there's actually a lot to consider. So we're going to do our best to break that down and talk about what pieces of this we might want to consider. And this should relate to paying employees in general in your business. So we are going to plan on right now and throughout this series, we're going to plan on talking about situations and how the different statutes fit into them and legal guidance. And that way we'll be able to kind of walk through the material, but also look at it from a practical matter. So all of that said, we're going to spend some time talking about the Fair Labor and Standards Act, because this is one that comes up a lot that we know can be a bit confusing. So kind of from a bird's eye view, the purpose of the Fair Labor and Standards Act is establishing anything really that relates to paying employees, and especially as it relates to minimum wage, overtime, record keeping, and youth employment standards. And so for our purposes, we kind of assume that most employers fall under this, including nonprofits. So the key things that we usually get questions about and like to look at is it dictates minimum wage. So it sets a federal minimum wage rate that all employers under the statute should be paying their employees. And it also requires overtime pay. So you might know that that rate is 1.5 times the regular rate for hours worked over 40 if an employee is non-exempt. And so we'll talk about that in just a minute. But this statute also decides and explains whether employees are required to receive overtime or are not required to receive overtime. So again, we'll touch on that in just a minute, but that's one piece that's a big part of this consideration. It also addresses record keeping, so maintaining accurate records of how much employees are working, what they're being paid, other details. And also, it's the statute that sets the youth employment rules. So things like age and restrictions for employing minors. So, as I was kind of hinting to earlier, when we talk about minimum wage and whether employees get paid minimum wage or not, um, that is all addressed by the FLSA, and it has to do with how the employee is classified. So, every employee across different organizations is, whether you know it or not, either exempt or classified as non-exempt. So if an employee is exempt, then that means that they get paid a salary and they do not receive overtime. And there's certain requirements that are at play to see whether an employee can be exempt. And then the other category is non-exempt employees, and those employees are eligible for overtime pay for any hours worked over 40 hours in the work week, like we said. So there's a couple different ways that there's basically the FLSA, when we talk about how to determine whether an employee is exempt or non-exempt, there's different tests that we apply to a given employee to figure it out. So oftentimes it might be a default to pay an employee a salary and to think they might not be entitled to overtime, but they really have to qualify with these certain requirements for an employer to do that. So they have to qualify as exempt. An employee must be able to pass the salary basis test and the duties test. So it's both of those. And the salary basis test means that an employee must generally have to be paid at least $844 per week. And as this notes here on the slide, that's as of July 1st, 2024. So just something to kind of keep in mind when we're talking about exempt versus non-exempt employees and how they're classified, is that these rules, they change to some degree as time goes on, and especially the amount of salary that is required under the salary basis test. So this is just something we would advise you to keep making sure you're looking up and being aware of, because it does get updated sometimes, on a yearly basis, or sometimes more or less than that. So it's good to know. And then the other test is the duties test. So there's certain types of jobs that can be considered exempt, and they apply to different roles that could be executive, administrative, professional, and other types of roles. And we'll get into that in a little more detail too. But the important thing to remember is that every employee is either exempt or non-exempt, meaning that they either qualify for overtime pay or they do not. And if you are going to classify an employee as exempt, they must pass both of these tests, the salary basis test and the duties test.
And Alex, I just wanted to point out that I don't think it can be overemphasized that most employees are non-exempt. And so
Yes.
when we get into these tests, please bear in mind that the employee is presumed to be non-exempt unless they fit into one of the specific exemptions.
Yes, that's exactly right. Thanks for pointing that out, Lori. That's the most important thing, I think, to take away from this whole exempt versus non-exempt conversation, is that the default is that they would be non-exempt. And if they are exempt, there's all these requirements that are needed. So the common exemptions that may apply to nonprofit employees, one of them is the executive exemption. And actually, if we could go to the next slide. Thank
Sorry
you.
about that.
That's okay. So the executive exemption has a couple of different requirements. So it's not enough just to say, oh, this person's title is an executive, so that means that they fall under this. Not quite. It actually really relates to what the duties are, because the statute lays out very specific requirements. So first of all is that the primary duty is in management of the company or a department. Typically, and they also need to customarily and regularly direct the work of 2 or more full-time employees. Or if it's not two, then the equivalent of two full-time employees. So if it's one full-time employee and two part-times employees that work 80 hours combined, that could fall under this. And then lastly, they must have the authority to hire or fire other employees and make recommendations that carry weight on significant employment decisions. So all of those need to be met to qualify under the executive exemption. And then another one that comes up often in the nonprofit space especially is the administrative exemption. So again, not enough to just say that person's administrative and maybe they meet the salary basis test so they can be exempt. Not quite. They have to make sure we have to make sure we dig in a little bit to make sure someone falls into the administrative exemption. So to do that, the primary duty must be performing office or non-manual work directly related to the management and or general business operations of the company or the company's clients. And then they also have to have work that includes exercise of discretion and independent judgment with respect to matters of significance. So those are all somewhat technical words, it seems, but these are the baselines that we use to determine whether an employee is exempt or non-exempt. So with all that in mind, that was a lot of information, but we can go back to thinking about Mark. So we know that, and I don't know that, Lori, did you want to go back to that slide or should we go ahead and just
No,
discuss?
go ahead and talk about it.
Okay,
But
we'll just talk
on
about
this
it. It's
slide.
great.
Mhm.
Okay, so it said that Mark was a program director and he was promoted and he had the authority to make decisions related to programming and related to the employment of two part-time employees. So with that being the case, it seems that his duties would likely fall into this administrative exemption. So if we're just looking at the duties he performs and his roles, it's likely that he'd fall into the executive exemption.
No, the administrative
Oh, sorry.
exemption, Alex.
Sorry. Thank you.
Mhm.
Excuse me. Didn't mean to misspeak.
Because
Okay.
he only manages two part-time employees, so he doesn't
Exactly.
manage the equivalent of two full-times. So he wouldn't
Thank you,
fall into
Lori.
the executive exemption.
See, I'm getting tripped up too and saying the wrong one. So this would be the administrative exemption. But something to think about is that we also need to look at the salary test. And so because he's not paid the minimum requirement amount, he would still be non-exempt. And that's based on the change of the threshold that occurred on July 1st, because he's not making enough to qualify under that exemption. So the answer to our poll question is, with all of that information, that Happy Care would owe him overtime pay for those 3 extra hours that he worked. And then one thing to mention is that if there was a different scenario where he maybe was able to take 3 hours off during that week to make up for the 3 hours he worked overtime so that he only had 40 hours in a week total, that would be the only way he would be able that Happy Care would not pay him overtime for that week. So like we said, these statutes do change. So we wanted to make sure we talk about recent developments for the different statutes we're discussing today. So the biggest one that we've already touched on is that there's an updated salary threshold for exempt employees. So like we said, the July 1st, the Department of Labor raised the minimum salary threshold to $43,888 per year. And we want to note that it's also changing again soon. So on January 1st, 2025, the threshold will increase again. So when this happens, there's times where it's challenged. So there are some challenges pending to the law that's been already put in place, but that's typically a slow process. And it's best to really operate under the assumption that these will be in place as they state, because we can't, like the slide says, we can't rely on courts overturning the changes until they happen.
Great. And Alex, one question that I've been getting a lot from our nonprofit clients is, does it make sense to raise salaries in order to meet this new salary threshold? Because some of the salaries of people who clearly have exempt duties do not meet this threshold. And it's something that nonprofits really have to think about very carefully because there continue to be changes. And so if you raise someone's salary to meet the July 1st threshold change, you may have to do that again on January 1st so that that person will remain exempt. The other option is to allow the position to become non-exempt. And in that situation, you need to start to treat that employee like a non-exempt employee. So you'll have to obtain time cards, track their time, and really manage their overtime. And so as an organization, you really have to decide if you are more comfortable or able to raise salaries, which certainly is cost prohibitive for many organizations, or if you're going to have to really manage the time of a group of non-exempt employees who formerly were exempt. And it's going to be really important to manage their time, to keep timesheets for them, and to make sure that you're treating them as non-exempt employees to comply with the Fair Labor Standards Act requirements.
Absolutely. Thanks for bringing that up, Lori. And that
Sure.
also leads really well into our next slide, which is still related to the FLSA in talking about compliance. So we want to also make sure to give some practical advice about how to make sure that you're insulated from liability under these laws and how to best comply with them in general. So like it says, it's best to comply with the FLSA. And some of the things that we can do to do that is one is to put the job descriptions of your employees in writing. And that way it's clear what duties they're performing, what their responsibilities are. And importantly, though, making sure that those job descriptions are accurate. Because a job description alone is not going to be the thing that determines whether an employee is exempt or non-exempt. It really matters what they're actually doing day to day when we look at these different tests to determine whether an employee would be classified as exempt or non-exempt. So again, writing down those job descriptions and having awareness and making sure their accuracy and doing those on an updated basis if needed. Keeping in mind that most employees are non-exempt. And like Lori was just mentioning, this is especially true when the salary thresholds are changing. It's best to kind of default to assume that they're non-exempt and make those determinations that she was describing as needed. Yes. Okay. So then another thing about overtime pay is making sure employees are all paid overtime for every hour worked over 40 in 1 week. So not allowing employees to work if they're off the clock. They need to be paid for all of their hours that are worked. And if an employee works there in a way that they were required to be approved, you can discipline if they were working when they were not supposed to be, but you still must pay that employee. And kind of relating to all of this is having employees keep accurate time records, because that's the only way that employers can really make sure that they're complying with these laws appropriately.
Great. Thanks, Alex. And Sarisha, I don't know if there are any questions about this aspect of the Fair Labor Standards Act before we move on to our next section.
Well, you actually already answered one of the slides when you were discussing whether or not to raise salaries or continue with the old salaries. But one person did ask, and will the new minimum salary threshold for exempt employees apply to those employees who are working only 30 hours per week as opposed to 40?
The salary thresholds apply to all positions. So if you have someone who's working 30 hours a week and you're not paying them at the salary threshold, they're going to be non-exempt. But you might not have a significant overtime issue because they're only working 30 hours a week, and you only have to pay them overtime if they work over 40. So you would have to determine, if somebody's working extra hours, you might have to pay them at their regular rate for, you know, hours up to 40. But once they exceed 40, you'd have to pay them overtime because that employee making less than the 43,888 would be non-exempt.
And one other question that we see quite often about timesheets, do exempt employees need to keep a timesheet?
Based on the Fair Labor Standards Act, they don't, but in some organizations, they, I know that they have grant requirements where they have to track people's time and what time they're spending on particular grant-based work, but that's totally separate from the Fair Labor Standards Act and the FLSA's requirements.
Thank you.
Sure. Well, let's talk a little bit more about our friends at Happy Care Builders. So, here's some information about a couple of other individuals who work for Happy Care. Sarah, one of the employees, brought Ben, an acquaintance of hers, in as a volunteer for a few weeks to help with some maintenance work. And the organization's executive director, Lisa, decided that he was doing such a great job that she wanted him to continue to do work for the organization. And so she engaged him as an independent contractor. He's been assisting the maintenance department in this capacity for the last 6 months, and he works with the organization about 20 hours every week, doing tasks that are assigned by Lisa, and he submits invoices to be paid. So once again, let me ask the audience a question, and that is, should Ben have been brought in as an employee or an independent contractor? What are your thoughts about Ben's status with the organization? And Randy, if you could launch the poll, I would appreciate it. Just give you a second to answer there. And let's share the result. It looks like it's somewhat evenly split between people who think that he's an employee or might be an independent contractor and those who are not sure. And that, so let's see, did I share? There, yes. And again, it's not surprising that you might be a little bit confused about whether Ben should be a contractor or an employee of Happy Care. So let's talk a little bit about the distinctions between contractors and employees and try to determine where Ben might fit in that scheme. So one thing that I want to be sure to share with you is that, you know, while it might be sort of less costly for the organization to have a contractor because you don't necessarily have to withhold taxes and pay them into the system, there are different rules that relate to contractors. Contractors are a little bit more independent and work on their own and typically have their own insurance and things like that. And even though the individual might prefer to be a contractor, this is really not a choice that the parties get to make on their own. Federal agencies like the Department of Labor and the Internal Revenue Service have specific tests that they use to determine whether an individual should be an employee or a contractor. And you should know as an employer that the presumption is that a worker should be an employee in most circumstances. Let's talk a little bit about the factors that the agencies use to determine whether someone is an independent contractor or an employee. And this slide includes some of the considerations that go into that analysis. What the Department of Labor typically does is look at the full picture of the worker's relationship with the organization. And they look at really 6 factors that go into whether someone is an independent contractor or an employee. And those factors revolve around the nature and degree of control that the employer exercises over the individual, how related the work is that the individual is doing to the mission of the organization. So is it fundamental to what the organization is doing, or is it something more peripheral to what the organization is doing? how economically dependent is this individual on the organization? Is this their only job? Are they in business for themselves, where they do this kind of work for a whole host of organizations? Or are they only working for your organization? Does this worker purchase their own equipment? Do they provide their own facilities? Do they have some kind of personal investment, financial investment into the way that the work is being done? Or is all the financial control on the organization? Does the work that the independent contractor is doing require skill and independent judgment? Or is it really something that is more directed or part of the regular business of the organization? And finally, how permanent is the relationship? Is this an ongoing long-term arrangement, or is this a project-based arrangement where the worker is performing a project, and when the project is finished, that worker doesn't work for the organization anymore? So these agencies are looking for the full circumstances. And while you may have an agreement with someone that says that they're an independent contractor, if many of these factors dictate otherwise, the agreement is not going to help determine the status of that individual. The agencies will really look at what this person is doing on a day-to-day basis to help determine whether or not the individual is a contractor or an employee. And I did want to share with you that the Department of Labor and other agencies are really focusing on this issue. Worker misclassification has become just a huge issue with regard to organizations and employers. We're seeing a lot of attention being paid to this. And one of the ways that it often comes to the attention of the Department of Labor, and this has happened recently, and I will say with several clients with whom I've been working, what happens is that you're working with an individual who you think is an independent contractor. And everything is going along very well until the funding gets cut, and you have to cut the contract, and you have to terminate the contract of this particular individual, and the work needs to stop. And the individual who has been doing work for your organization decides that they're going to go and file an unemployment claim with the Georgia Department of Labor. And they file that unemployment claim, and the Department of Labor realizes that they have no record of this worker. And then they send a questionnaire to you as the employer. And when you fill out the questionnaire, the Department of Labor starts looking at whether this individual should have been an independent contractor or whether they should have been an employee. And often they will grant benefits and determine that this person should have been an employee and not an independent contractor. So it's something that is really coming to the attention of the agencies, particularly at this time. And there's a real focus on it. So you want to do a very careful analysis in your workplace of anyone who's working for you who is currently being treated as an independent contractor. And let's go back for a minute before I talk about a few of the other things on this slide. Let's go back for a minute to talk about the situation involving Ben. Because Ben was brought on as a maintenance worker. Lisa is directing all the work that he does with the organization. So the organization has a significant amount of control. The organization is in business to build, maintain, and run childcare centers. And he's doing maintenance on those childcare centers on a day-to-day basis. So it's pretty important to the work that the organization does. We didn't say whether or not this is the only job that Ben has, so we don't know that information, but he does work there 20 hours a week, every week. And so he's spending a significant amount of time doing work for the organization. And he's been doing this on an ongoing basis for 6 months without any indication that the work is going to end. So I would certainly argue that it is more likely that Ben is an employee than an independent contractor, as the organization has been classifying him, and that there's significant risk here for the organization if they continue to employ him as an independent contractor, where most of these factors dictate that he is most likely an employee. So that's certainly something to think about as you are considering bringing workers on and how you bring them on to do work for the organization. One thing I really wanted to mention to you is that there's been a recent case in our circuit, the 11th Circuit Court of Appeals, that clarified when individual managers and supervisors can be held responsible for violations of the Fair Labor Standards Act. So that would be misclassifications in the workplace, or misclassifications as to exempt or non-exempt, as Alex talked about earlier. And I just want you to know that what the court has said is that an employer under the Fair Labor Standards Act who can be held liable for violations of this law is anyone who has direct responsibility for the supervision of an employee. So if you in your personal capacity are making decisions about employment for particular individuals and your decisions result in the violation of the Fair Labor Standards Act, for example, if you tell someone to work off the clock, if you falsify a timesheet, not that any managers on this call would do that. If you, if you know that an employee should be classified as non-exempt and you're treating them as exempt and refusing to pay them overtime, you can be held personally liable for those decisions that you've made in the workplace, in addition to the organization having liability. So this is an extremely significant area where you want to be sure that you are in compliance with the law. So I wanted to be sure to emphasize that to you as we're talking about the Fair Labor Standards Act and as we're talking about these different types of misclassification that might occur. And one other thing that I did want to mention is that the Department of Labor recently issued some new guidance on teleworking and tracking hours for remote workers. And they really re-emphasized that you're required to pay for all hours worked, even if an employee is working from home or remotely. So you want to make sure you have very good systems for determining and tracking when people are working and when they're not working. And Alex, I don't know if you have anything you wanted to add there.
I think you covered it well. Thank you.
Okay. And Sarisha, did we have any questions on that subject about independent contractors or employees or anything we've talked about just now?
We do have one question from one of our audience members asking, what about, you mentioned about a scenario where someone goes in, an ex-employee goes and applies for unemployment, and that might be where this comes up. They're asking, are there other situations? Who can bring up this issue? Is it only the individuals, the former employees, or can the government also look into an organization? And they say explicitly, we're not trying to not do the right thing, just trying to get an understanding.
Yeah, I hate to tell you, but yes, the government can look into this. Typically it comes to their attention in some way, but what could easily happen is that they get an unemployment claim like the one that I just described to you, and then they start to look at the whole rest of the workforce. And so you may have had one person who went and filed for unemployment, but then you have 5 people who you're treating as independent contractors, and the Department of Labor might choose to look at all of them. Sort of spontaneously without any of those other people raising any concerns or issues. And it's also within the jurisdiction of the IRS, which, I can't say that I can cite to a situation that I'm aware of where the IRS came in without some, without some instigation to them or without some information being shared with them, but it could happen. They have the jurisdiction to do it if they wanted to. So there is certainly significant risk if your organization were to come to the attention in one way or another to any of these federal or Georgia state agencies.
And one more question about timekeeping, timesheets. Do you have any suggestions for how to track hours for a remote employee, a remote worker?
Well, I mean, you need to track them, and Alex, feel free to chime in, of course. You need to track them the same way you would track an employee who's working in your workplace. And, you can track time however you prefer to do so. You can do it electronically, you can do it on paper, as some of us old-fashioned people like to do. But one thing that I would make sure that you do is assure that the employee has to sort of affirm in some way that the time that they're reporting to you is accurate. So, at the bottom of the timesheet, when we used to do it that way, I would always put a statement that said, something about the employee signing off on the accuracy. I affirm that the time that I'm reporting is true and accurate. And there are ways to do that electronically as well. So you just want to make sure that that employees are told they have to report their time accurately, that they are affirming that the time is accurate, that if you have supervisors checking it, that they're affirming that the time is accurate. And if you find out that someone is not accurately reporting their time, you should take disciplinary action to address it. So there's a deterrent in the workplace if you were to discover that someone is not doing what they're supposed to be doing. And Alex, I don't know if you have any other suggestions in that
Yeah,
regard.
the only thing I would add is that just kind of from a practical standpoint, when we look at teleworking and remote work, that might be a situation where it would probably behoove you to have some sort of electronic timekeeping records, just because making sure that you have access to all those records is also important. So you wouldn't want things to be kept in paper in a place that you don't have access to or don't know where it may be. So that's just another piece just to add is from a practical standpoint.
Makes sense. Great. Thank you. And I think we're going to revisit our friends at Happy Care Builders. And Alex, that's for you.
All right. So to wrap up our last situation, Ben was hired as an employee thanks to Lori's recommendation after Lisa considered the risks of maintaining his independent contractor status. And then something else came up that will implicate some other pieces we'll talk about. So one day, Lisa calls Ben and asked him to help with some improvements being made at one of the care centers. Lisa expects that the work will take about 6 weeks. Sarah's office is in the same center and near the area where the work will be done. Ben will be repairing and painting one of the play areas and the outside walls of the building and then maintaining the area, including spraying for mosquitoes. So we're going to learn more about Sarah because we just met her. Ben gets started with the painting. Sarah comes outside to see what Ben is doing and starts to cough. The next day, Sarah pokes her head into Lisa's office, and Lisa has just hung up from a phone call. Sarah tells Lisa that she's pregnant and asks to move to a different location while the work is being done since the chemicals are bothering her. Lisa tells Sarah that there is no other space for her and saying that the work needs to be done where her office is now. So we'll do another poll here. Does Happy Care need to accommodate Sarah's request?
Lori, could you go back to the previous screen so that folks, if they need to reference the fact pattern, they can take a look at it again?
I don't think I can do it while the poll
Okay.
is going, but here, let me end the poll and share the results.
Okay, so it looks like the results are unanimous in this situation that Happy Care needs to accommodate Sarah's request. So I would agree with that recommendation. It seems like we got some savvy employment folks here. So we can go ahead and talk about why. And with this situation, it really does implicate quite a few different statutes, but the most relevant is a very recent one, which just was enacted last year in 2023, which is called the Pregnant Workers Fairness Act. So this pregnancy was covered under some other statutes in different ways and still is, but this is the first statute that really head on addresses pregnancy and related issues directly and creates some more needs to accommodate pregnant workers. So the purpose is requiring employers to provide accommodations to workers affected by pregnancy, childbirth, or related medical conditions. And this applies to any employers with 15 or more employees, including nonprofits. So that 15 or more employees number applies to a couple of the different anti-discrimination and harassment statutes. So we'll talk some more about that, but that's a good number to keep in mind to see what applies to your organization. And the key aspects of the Pregnant Workers Fairness Act, the first is reasonable accommodations. So again, we see this in some other statutes that we'll continue to look at, but the biggest thing is if you have an employee that is affected by a pregnancy or a related condition, being there to modify work duties, working with the employee to figure out if they need breaks, temporary leave, it could really be a huge range of different options that could qualify as a reasonable accommodation, but that is employers are required to engage in a process to find a reasonable accommodation under these circumstances. It also has a provision regarding non-discrimination, so it prevents employers from discriminating or retaliating against employees based on pregnancy or related conditions. And then it also puts an obligation on employers to provide a safe working environment for pregnant employees, which of course is something that came up in our hypothetical that Sarah was working in an area where she might have been exposed to chemicals. And as a pregnant employee, there may be obligation on the organization to ensure a safe working environment for her. Even though this is a really recent law, there was still recent guidance that just came out in the past few months that has given us additional understanding of how to best comply with this law. So one of the most recent changes is that there was guidance to cover a broad range of pregnancy related conditions. So again, while the statute's titled the Pregnant Workers Fairness Act, it actually does involve other conditions as well, and quite a lot. So that includes conditions related to abortion, miscarriage, fertility treatments, stillbirth, and menstruation, just as some examples. And there's even more that fall under this category. It also expanded the EEOC guidance has expanded accommodations. So at first, it may have been a little more vague about what was considered a reasonable accommodation, but it's now clear that options that employers should look to include things like flexible work schedules, breaks, remote work. Employers should be looking at all of these types of options when determining the best accommodation for an employee under this act. There's also a more simplified process. So an employer does not have to request medical documentation for pregnancy accommodations. So it can be enough if an employee simply tells their employer that they are pregnant. An employer does not have to request any documentation or review that when looking into accommodations. The interactive process is the process that employers are required to engage in with employees to look at accommodations. So the laws make it clear that if you have an employee that is affected by the statute, whether it's by pregnancy or related condition, the employer has an obligation to respond timely and engage in a good faith effort to find an accommodation. So an employer wouldn't just be able to say, oh, we can't figure out something that's going to work. Sorry, something quick and definitive like that. There's really an obligation to engage in efforts with the employee to find an accommodation that is adequate. And then the last update that we've gotten from recent guidance is related to record keeping and reporting. So just be aware that in 2024, there was implemented some additional guidance for record keeping about the accommodations that the employee requested and then also that the employer provided. So when we look at pregnancy related conditions, like we mentioned earlier, there was also already kind of some protections and laws at play outside of the Pregnant Workers Fairness Act. And we're going to talk about each of these in a bit more detail. But just wanted to mention that Title VII also prevents discrimination based on pregnancy. It also requires reasonable accommodation of religious practices. And then also, and these are also just statutes that we're going to talk about related to other issues besides just pregnancy, but wanted to bring up in this context as well. The Americans with Disabilities Act requires reasonable accommodations for disabilities in the workplace. The PUMP Act was enacted recently, and that's expanding protections for nursing mother. So employers are required to provide break time and private space for nursing mothers. And there's a Georgia law on this as well. And there's also the Family and Medical Leave Act, which provides leave entitlement for eligible employees if the employer has 50 or more employees. And just wanted to also mention that as far as recent guidance goes, that some of the guidance we've also received is that remote workers and employees are also FMLA eligible. And also there was guidance recently regarding work week holidays. So holidays that occur during the work week do not reduce the amount of leave that's entitled under the FMLA. As far as additional recent developments, so we talked a bit about accommodations under under the Pregnant Workers Fairness Act, and we also wanted to mention the obligation for religious accommodations under Title VII. So under this statute, if an employee has an accommodation that they request based on their religion, then there's certain obligations on employers, and that was changed a little bit recently of how employers operate under this system because of a new case that came out. So basically, prior to this new decision, when an employer was looking at an accommodation for an employee based on religion, if it was denied, an employer had to show that the accommodation would result in a minimal hardship. And now there's a greater burden. So now, after this new court case came about, an employer has to show that granting an accommodation would have resulted in a substantial increased cost in relation to the conduct of its particular business. So it just raises that bar a little bit higher on the obligation for employers to find religious accommodations for employees that request them. Lori, was
Yeah.
there anything you wanted to add there?
Alex, I did want to mention that, I thought it was really interesting in this Groff versus DeJoy case. What happened was that there was an employee, it was the Postal Service that was the defendant in this case. And the employee didn't want to work on Sundays for religious reasons. And the Postal Service denied the request because it was an imposition on the employee's coworkers, and the coworkers would all have to work on Sundays to cover the shifts that this employee would normally have had to cover. And the court held that the sort of disruption to the coworkers was not sufficient to deny the religious accommodation, which really contradicted a lot of prior cases where such a sort of minimal disruption would have been enough, where the inconvenience to the other coworkers would have been enough. So if you do get a claim of, from someone asking for an accommodation of their religion, you really do need to examine it very carefully and think about what the impact is on your business, as opposed to just the impact on other people who are working for you, to be able to make a case if you aren't able to provide the accommodation. So it's really going to be a lot harder to defend the denial of an accommodation after this case. So thanks, Alex. Yeah, it's really an interesting and very significant change to a law that's been operating a certain way for quite a long time. Okay, anything else on that, Alex, or any questions for us at this point, Sarisha?
We do have one question about asking for medical documentation. If an employer asks for medical documentation, can they do that? Or what if an employee says no? They refuse to provide it.
Alex, I don't know if you have some thoughts about that.
I think that it depends on the purpose of the medical documentation. If the employee is requesting an accommodation, especially if it's based on a disability or something related to that, and then, if they're requesting the accommodation and then refuse to provide the medical information, that becomes a problem because the employer does have a right to look and examine that situation with the insight of the medical writings. So really, if the employee is the one requesting that accommodation, the employer should be entitled to that information.
Right, and I think that also applies under the new pregnancy accommodation requirements, even though the employer could choose not to
Yes.
ask for that
Yes, that's important
information.
to mention too. That's
Mhm.
very much the case. Yes.
Okay. Okay, well, after hearing all that great information that Alex shared, Lisa rethought her response to Sarah with regard to her request for accommodation of her pregnancy. And she went back to Sarah and said that she was really distracted by another work issue yesterday. She's so excited about Sarah's pregnancy and congratulated her. And she scheduled a meeting with Sarah to discuss the options for addressing Sarah's concern about the work environment. They agree that Ben is going to work in the facility where Sarah is only in the morning, and Sarah will work from home during that time. And then she'll come into the facility in the afternoon when no work is being done and no chemicals are being used. And Sarah, she thinks about it for a little bit and she thinks that that's a really good solution. And she tells Lisa that she's satisfied and thanks her for her help in resolving that issue. So really think through if an employee comes to you looking for an accommodation, just don't dismiss it offhandedly. Be sure that you think it through and talk to the employee about what their needs are and what you may be able to do to help address the situation with them. Well, let's go back and talk about Mark again. Mark was the first employee who we met from Happy Care Builders. And Mark, who is now the program director, as you might remember, directly supervises two part-time employees, a white man named Kevin and a Black woman named Stella. Mark grants Kevin's request for time off to visit his dying sister. And when Kevin returns, Mark confronts him and yells at him for not reading his damn email, excuse my expletive, while he was away. From then on, Mark regularly hovers over Kevin as he works to make sure he doesn't mess up. Mark yells and shakes his fist at Kevin whenever he's angry at him. And he doesn't behave that way with Stella. And although he's sometimes irritable in general, he usually engages in friendly banter with her. Mark even sometimes lets Stella leave the office early and doesn't really monitor her work performance at all. So do you think that Mark's behavior is creating some risk for Happy Care? What are your thoughts about that? Oh. Looks like everyone is pretty much agreed that Mark's behavior is creating some risk here for Happy Care. And you certainly would be right. Oops. Let's talk a little bit about Title VII of the Civil Rights Act of 1964, which Alex mentioned to you earlier. Title VII prohibits employment discrimination and harassment based on race, color, religion, sex, and national origin. And as Alex, I think, mentioned earlier, it applies to employers with 15 or more employees. So it applies to Happy Care because they have 25 employees. One thing that you should know about Title VII, which is becoming more and more prominent these days as lawsuits continue to be filed, is that it protects all employees, regardless of their race, color, religion, sex, or national origin, even those who are in groups that have not historically been subjected to discrimination. And I know there's been a lot of attention in recent months on several cases that have come down from the Supreme Court and from courts in Georgia that have addressed race discrimination issues. Most of them have been outside of the employment context, but we thought it was important to mention them here because we feel like they're going to have implications for the employment context. And so there was an affirmative action case related to universities where a university system that had a preference for Black individuals was struck down. And now the Fearless Fund case has been decided in Georgia, which was a case challenging race and gender-based grant making. And that has been struck down as a violation, not of this statute, the Civil Rights Act of 1964, but of Section 1981, which is a statute that prohibits race discrimination in the making of contracts that applies to all employers. It doesn't have this 15 employee limitation. So that those cases are out there and certainly influencing what's going on with regard to employment discrimination at this point and diversity, equity, and inclusion programs. So that's something that we're certainly keeping an eye on, and that we're gonna, oops, sorry, what happened? Here we go, sorry, that we're going to talk about in just a few minutes. But I did want to call your attention to another development that relates to harassment in the workplace under Title VII, because the Equal Employment Opportunity Commission has issued a new guidance on harassment in the workplace. And it really addresses a number of sort of current and pressing issues. The first one is that the rules of Title VII apply even in a virtual work environment. And so if there are electronic communications going on, discussions over social media, the use of phones, computers, all of that could contribute to a hostile work environment in the workplace. In addition, the EEOC says that employers can be held responsible for harassment that's based on an employee's personal activity outside of the workplace, including over social media. And basically what they say is if someone's conduct has consequences within the workplace, even if it happens outside of the workplace, it can still create a hostile work environment. And the EEOC provides this example. An Arab American employee is the subject of ethnic epithets that a coworker posts on a personal social media page, and the employee learns about the post directly, or other coworkers see the comment and start discussing it at work. Then the social media post can contribute to a racially hostile work environment. So, behavior outside the workplace that has impact within the workplace can be the basis for a claim of harassment. I think, as I already said, actionable harassment can occur among employees of the same race, age, religion, gender, sexual orientation, or other protected class. Another example that the EEOC gives, a Black woman alleged she was the subject of her two Black coworkers' harassing conduct at work, culminating in an offensive race-based Instagram post. Based on these facts, the EEOC investigator found that the conduct, including the social media post, created a hostile work environment, even though all those people were of the same race. So any individual is protected from inappropriate conduct by any other individual in the workplace. Title VII includes, as you may already know, harassment based on sexual orientation and gender identity and expression. The definition of harassment includes harassment based on pregnancy, childbirth, and related medical conditions, as Alex talked about earlier. And one other thing that it's really important to point out that the EEOC has emphasized and focused on is that if an organization takes reasonable corrective action in response to a complaint, where a supervisor let me start that again. If an employee complains to a supervisor and the supervisor fails to report or address the behavior, the organization can lose its defense to the hostile work environment claim, even if it has a policy that says that it will take appropriate action. If the supervisor fails to do what they're supposed to do, then the organization can lose its defense. So that really emphasizes the importance of making sure that supervisors and managers in your workplace understand how to respond if an employee raises a concern internally and where to escalate those concerns to, so that you never have a situation where someone complains about harassment or discrimination in the workplace and the organization has done nothing to address those concerns. I mentioned earlier, Section 1981, which is a law that prohibits race discrimination in the making of contracts, and which was also the law that was addressed in the Fearless Fund issue that arose. And both Title VII and Section 1981 have been used recently to bring cases in what I'll call groups that have not historically been the subject of discrimination. So more and more frequently, white employees are bringing lawsuits, challenging their treatment in the workplace. And I'm seeing concerns like this on almost a daily basis being raised by my clients. So be aware that Title VII and Section 1981 perhaps protect everyone. And Alex, did you want to talk about the ADEA?
Yes, so we are going to briefly go over the ADEA as well. So this is a statute that prohibits employment discrimination against those that are 40 years of age and older. The application is a little different because it applies to employers with 20 or more employees, but does include nonprofits. And the discrimination protections would cover hiring and firing, so no discrimination in those decisions or other employment practices based on age, specifically, again, if the employee is 40 years or older. And then also it provides for equal treatment in job assignments, trainings, promotions. And lastly, it also provides mandatory benefits. So employees that are over the age of 40 must be provided equal benefits, including retirement and health benefits under the ADEA. And then briefly, again, we're going to cover the ADA, which is discrimination against those with disabilities, including employment. It also relates to public spaces, but we're going to focus on the employment aspect. And this applies to employers with 15 or more employees. And the key provisions, which we've discussed briefly already, are preventing discrimination for employment practices against those with disabilities, and also creates an obligation for employers to provide reasonable accommodations for those with disabilities at work. So this is an example of a recent development under the ADA. This is a case that came out just last month. And in this situation, it involved an employee with severe allergies who was working for in a private office for a while and then worked from home for a certain period of time. When the employee came back to the office, they wanted to avoid their coworker's perfume. And so he requested a private office at his workplace. And the employer, instead of granting that accommodation or looking into a similar accommodation, the employer only offered him the option to work from home. And the employee did not want to do this. He didn't want to work at home. He thought that he'd be more helped by working in the office for in-person collaboration and just wanted a private space. And the employer said no. And basically, the court's ultimate decision and why it's important to keep in mind is that just because an employer used an accommodation in the past that worked doesn't mean that that's the only one that can be available. An employer still has an obligation to discuss the options and engage in what we call the interactive process with the employee that's requesting the accommodation, to take into consideration the circumstances and to attempt to find an accommodation that works for everyone. And then lastly, we want to talk about practical considerations under all of the statutes we talked about today. I know we specifically got into some advice regarding the FLSA, and these pieces will go to everything we talked about today. So the first is to develop clear policies, especially as it relates to anti-discrimination and harassment. So we want to make sure that policies are very clear about the procedure for reporting complaints, addressing complaints, what the process will be. We want to make sure policies define exactly what is prohibited. We want to make sure they mention that employers cannot retaliate for reporting violation of these policies and that such reports are confidential. We also want to make sure that your organizations are conducting trainings. So we want to make sure that employees and managers especially have trainings and understanding of the policy requirements that are put in place, including respectful workplace practices and how to address any concerns. Record keeping is always something that we're going to recommend. Your lawyers will always tell you to do this, to maintain records of all employment practices, including hiring, firing, promotions, work hours, job duties, and disciplinary actions. Those things relate to so many and many times multiple of the statutes and considerations we discussed today. So having those in place is really important. When it comes to reasonable accommodations, making sure that there is an accommodations process in place for religious practices, disabilities, and pregnant workers, and also making sure that those accommodations processes are written and clear and communicated well to employees. Accessibility is another piece. So when it comes to the ADA, making sure that, and the Pregnant Workers Fairness Act, making sure that the physical spaces are accessible to those with disabilities or potentially an employee that's affected by the Pregnant Workers Fairness Act. And lastly is reviewing and auditing. So even though you have a policy in place, just making sure to review those commonly, especially in light of any recent developments with the law, and making sure that they're up to date with the most recent guidance and compliance with the laws.
And I think we're happy to try to answer a few more questions, but I did want to mention, if you have specific questions about your workplace, please be sure. If you're a client of Pro Bono Partnership of Atlanta, please reach out to your staff attorney and they'll be glad to help you with specific questions. Whereas here, we're more than happy to answer any general questions you have.
Thank you, Lori. We did get some pretty specific questions, and so I did suggest that in those situations, folks should reach out to provide more background and speak to their attorney. But I did want to, there were a lot of questions about medical documentation, and this individual is asking specifically, what type of medical documentation could be expected for menstruation? Any thoughts on that?
It really depends on what the employee is asking for. You know, really the medical documentation that you would ask for in the situation of like a pregnancy accommodation request or a disability request is medical documentation to substantiate the need for the accommodation or for an accommodation. And so typically what you would do in asking for medical information, in my view, is you would share the job responsibilities that the person has and ask the doctor what the limitations are on the person's ability to do their job and whether they can perform the essential functions of the job with or without accommodations, and then what accommodations the doctor might recommend. So it's really very focused on, you know, you're not looking for just abstract information about the person's medical condition. You're looking for what the limitations are in that person's, you know, physical or other activities that would impact their ability to do the job. And I don't know if Alex has some other thoughts about that.
I think, like Lori said, it's just a really case specific situation. So as, you know, for this example of menstruation, is the employee asking for, you know, an hour off each month, or are they asking for and some other type of accommodation? I mean, maybe it breaks, maybe it could be just be so many things that it really would depend on a case by case basis, and whether it also would be your kind of judgment about what would be helpful or necessary to substantiate the request for an accommodation, especially as it relates to the Pregnant Workers Fairness Act. You know, if it's something that you can accommodate easily, that doesn't seem unreasonable, that you don't feel a need to request that documentation, then that's one thing. But if it's something that's really going to be impacting your business and that you feel there's a reason to substantiate it, then it might be a different situation.
Well, and I do want to also just say that you should be very cautious that you have a good reason for handling different situations differently. So if your regular practice is to ask for medical documentation, you'll typically want to do that in most, if not all cases. And if you make an exception to it, you're going to want to have a good business reason for why you did. Because you don't want to be in a position where you're treating people differently with regard to your processes for requesting accommodation or for dealing with any of these other issues that we've talked about.
Yeah, be consistent. And
right.
One more question I'm going to ask, because we are way over time, and I appreciate you, Lori and Alex, speaking with us and providing all this context today. But my last question is going back to the salary threshold updates. We have someone who is asking, does this apply to all employers, or is it just employers with some sort of minimum employee count?
It applies to all employers. Unfortunately, and there's no distinction in the Fair Labor Standards Act between nonprofits and other employers. Unfortunately, you know, I say this a lot, so people have probably heard me say it. Nonprofits don't seem to have a powerful enough lobby in Congress to get their own provisions in laws that are very burdensome to them. So we are usually in a position where you're required to comply with the same thing as major corporations. And it's really unfortunate because our perspective is not the same, but that is the way that the law works. So there you have it.
Well, audience, thank you so much for hanging in there with us and for joining us today and all these great questions. Thank you, Alex and Lori, for sharing your time and expertise with us. And our next presentation's in November about charitable solicitation. If anyone is interested in joining us for that, I included a link for registration in our chat. And that is it for this installment of PBPA's webcast series. Thanks, everyone.
Thank you.
Thank you.